Hey. And yes, we are live.
Hey guys, so we're back live, and we're just gonna sort of pick up where we left off. Louis, you want to segue?
Sure. So where were we? Sorry. I guess I was following up on your point, Gabe, about the potential liability for developers in open source systems.
Yes.
So I think this settlement and statements by Cont'd, the CFTC commissioner, a couple of weeks ago, indicate that the regulators are definitely focused and are willing and I guess able to bring cases against or enforcement actions against developers that are working on smart contracts, right? And especially those that they think are willfully designing contracts in ways to contravent existing law. A really interesting question in my mind is what are the limits of that liability, right? Because I think that argument starts to break down when you go from talking about developers that are willfully designing smart contracts to circumvent laws, and you start talking about developers at the protocol level that are making push requests on the Bitcoin Core client or the similar for the Ethereum blockchain, right? And to me, folks that are operating at that level, given the open source dynamics and given just the kind of general application of the protocol level technology, should be treated very differently by regulators. Although I do seem to notice a trend from regulators and others and starting to focus on devs. So I'm wondering what you guys think this says in that context.
Yeah, it's a bit of a slippery slope, right? I agree. I think there needs to be, as you start saying, merely deploying a prediction, prediction market style smart contract, ought to hold you liable, right? Because it's like reasonably foreseeable how it'll be used. I think you need something a little bit more specific than that. Otherwise you're going to really quite constrain software developers. And we've seen instances of software developers being like there was that guy at I think it was Volkswagen, right, who designed the software that was used to cheat the emissions tests, right? And he was held liable, like really severe, probably worse than what the founder of EtherDelta got. So yeah, I mean, there's a need for new standards, in this. I totally agree.
On the subject, Greg, of kind of clarity and certainty of the law, I think a lot of us might be concerned. We talked at the beginning about, the SEC did not enumerate which particular securities they were thinking of, but the period in question in the order is very brief. It's from the period from the Dow report to mid-December of 2017 when the business, whatever it was sold. And there really hadn't been that many public, at least, enforcement actions by the SEC in that period. Should folks be concerned about just the lack of clarity? The SEC said, well, we think they're mostly our securities. But, it's not clear to me, and the SEC never comes out and says this, that tokens that they had taken enforcement actions against were traded on the EtherDelta platform during that specific period when the platform was being operated by the party in question. So I'm curious, Greg, how much certainty do folks need to be subject to potential serious, liability?
Well, I think there's a couple of things there. So first, I thought that the order went out of its way to specifically cite to the Dow report and the section of that report that sort of talked about potential liability for unregistered exchanges or exchanges that weren't properly within an exemption from exchange registration. And so, clearly the SEC takes the position that the Dow report put people who were involved with exchange operations on notice about that sort of requirement. And the order also went out of its way to sort of identify the percentage of trades that occurred on the EtherDelta platform or through the EtherDelta platform, post Dow report. So I think that's another sort of factor that that relates to that. The SEC and obviously Chairman Clayton said that every ICO that they've seen, it has been a securities transaction. Whether they still take the position that that's true or not is an open question. But I think given that more than 500 different tokens were listed, and really, as I understand the exchange, it could facilitate a trade of any ERC20 token, whether it was listed or not. And so the question of which one of those 500 or which one of any ERC20 tokens actually constitutes a security, I mean, it's an interesting question, but I don't think it's the main point of this order. I think the order is basically looking at how the platform operated and applying the definition of an exchange to that operation and concluding that whether it's called a decentralized exchange or not, it's bringing together buyers and sellers of these tokens, and certainly some of these tokens would meet the definition of a security in the SEC's eyes.
But that's where I struggle with this, right? Looking at the SEC's, what their mission is supposed to be, and the way that they sort of approach this, right? Because the problem with not identifying, which tokens they thought were securities or whatever. I mean, one of the problems with it is that, what do people do about this? And how does it affect, the supposed victims of the crime, who bought these tokens, right? Because now EtherDelta in the US, because it listed like everything, ERC20, it was like, one of the main sources of liquidity, for people in the US who bought these tokens, right? You could always, there's one place you could always go to sell your quote unquote shitcoin, it was EtherDelta. And by, the SEC taking this approach, instead of, what I would do is the SEC, I would say, all right, we got some victims here. Let's go against the issuers. Let's get the issuers to, while they still have some money, right? And let's try to get them to give as much of the money back, to these investors as possible, right? What I wouldn't want to do is say, well, the one avenue that the investors have to still somewhat protect themselves, which is, maybe sell these tokens to someone else. Let's kill that, and let's not explain why or which ones it was based on, so that there's huge panic, and other exchanges probably react, by either excluding everyone in the U.S. Or just shutting down and trying to go dark completely. I mean, how does this really help the supposed victims of that, right? I think it's going to harm them in the short term.
I'll pick up on that because I think it's an incredibly important point. I disagree slightly. I think if the SEC wanted to listen in our little live cast here, they might say, well, it's not a very good result if, even if it's among two private parties, you resolve private party A's problem by selling the same crap coin to party B. But I don't think you need to get there for me to agree with you. And that's because the mere removal of liquidity actually drives down the price. So whatever value these particular tokens may have had, whether or not you were going to sell them, when you remove the liquidity from the marketplace, their value is going to plummet. Right. And so you wonder what investor protection is happening here, because you're not actually, and this is, you've made a good point, Gabe, you're not actually penalizing the people who raise the money. You're penalizing the people who have already invested the money and taking a step that very likely has a net result of reducing the value of their investment, if it was one, without actually penalizing the people who got it. So I think you've made an incredibly important.
And not only do you do that with ones that were securities, but assuming that some of them weren't securities, you're also potentially affecting the value of those, right? So that's what's tough, right? I agree.
Now, Greg, well, go ahead.
Let me just chime in, because I think the point you made is really an interesting one, and the order specifically when it set forth the Howey analysis, included a phrase that talked about secondary market trading and the relationship of that to potential price appreciation and the expectation of profits prong. And I think that, when the SEC is conducting their analysis and looking at whether the primary purpose of a purchaser is like consumptive use of a token versus investment intent, whether or not there's a secondary market or whether or not the token is sold in a manner that suggests there will be that liquidity and ability for price appreciation is something that they're very focused on.
Yeah, totally agree. The Gary Plastics case and all that. But still, I think, technically that's true. But it sort of seems like they're taking the position of, we're going to hurt some people in the short term, but we really, really just want to shut these markets down. And so, and they should have maybe known better anyway. And so we're just going to, go do this and start attacking these exchanges. I find that kind of weird personally, but.
By the way, EtherDelta is still up and running as of
yesterday. I know, but what the reaction is going to, there's going to be a reaction from this, and probably they will go after the whatever entity currently controls EtherDelta, right?
Yeah, no, Greg. So you had pointed out that a particular piece of the resolution of the order was that the respondent agreed to cooperate with future enforcement actions. Obviously, we don't know. We're speculating, and of course, we want to be very cautious when we speculate. But Gabe, as you suggested, it seems like among the permutations there of the cooperation might be further action against the owners. Now, I do not know who those owners are. I don't know if that's publicly known, but they're certainly understood to be outside of the United States. So I guess getting jurisdiction over whoever those owners may be challenging, but that there may be an interest in continuing to pursue this matter. I don't know, do you have any perspective on that, Greg?
Yeah, I mean, I think there probably are some real practical challenges in bringing new foreign owners of EtherDelta, the platform or the smart contract, in to the U.S. and moving forward with an action. But I think clearly the order sort of lays out the ways that that the platform was violating Section 5 of the Exchange Act, and they had to do that because liability for the respondent individual was sort of contingent upon him helping to cause that violation. And so the case against EtherDelta is already, and I think the fact that Coburn agreed as part of the resolution to provide testimony in any related action is a good indication that we could see an enforcement action in the future with respect to the new owners or perhaps with the entity or system itself. And then the other possibility that I was thinking of was, to the extent that there were efforts made by, sponsors of a token to get a token listed on the exchange, that would potentially be another way that could play out.
Yeah, one thing that intrigued me, and I think one of my online posts about this was, in another world where we had a quote unquote sandbox for entrepreneurs, would we've all been a lot better off to say, look, there are some, at least, tokens that are not securities. What would it look like, and how would we manage a platform that's meant to handle the trading of those tokens which are not? And could we work with you, the regulatory community, to build something that kind of works to achieve that goal? I think we all recognize if we're going to have blockchain-based ecosystems, parties need to transfer tokens among themselves to exchange, demand information and price information. That's how they work. Tokens that are purely consumptive get perhaps burned upon their use, but tokens in decentralized systems of necessity need to be transferred back and forth for those decentralized systems to work. And a concern is if we don't have a pathway to build those types of systems in a way that's consistent with the law, what, Gabe, as you had said, what we're going to see is people either build anonymous systems or they move the activity to other jurisdictions that are more constructive in the way they engage with the community.
Yeah, and I think part of, if you really sort of, you can get into all kinds of game theory and policy stuff about this, because like really think about that as a ripple effect, right? Like, now what if there's a crop of new Satoshis, in reaction to the current enforcement wave, and is that really the result the SEC or other regulators want, right? Because it is going to be hard for them to enforce against that. The whole, that is the selling point of blockchain, is that it's these quote unquote unstoppable, for all intents and purposes, applications. And so if you Monday morning quarterbacking, if you were to sort of like abstract away and try to think about, the best way this could have happened, the regulators could have done this, not that it's necessarily practical for them to do this, but if they had like all the power in the world, all the resources in the world, what would have been the best thing? The best thing would have been to create some safe harbors, right? And then start going and enforcing against some of the people who broke the laws in particularly egregious ways, right? And try to funnel that activity, right? And keep it going in a way where people can be rich and famous and make these things, as opposed to and creating the possibility for the SEC to enforce against the ones that mess up, versus a situation that we may end up getting into where people, maybe they can pick 2 out of 3 and get rich and not famous and launch one of these, and that would be bad for regulators and maybe kind of bad for society, right, if it ends up with more fraud and more illegal things happening.
So for folks who actually either are watching live, which would stun me, and or watching, on delay, because we'll further tweet out the link, and hopefully as people will pick this up again. One of the things that the team said amongst ourselves is we don't always agree with each other, and it's a very dynamic thing. So Gabe, on the point of a safe harbor, it is an interesting thing. It's been mooted a lot. Director Hinman, in remarks, I think at the PLI seminar earlier this week, Director Bill Hinman, who heads the Division of Corporation Finance at the SEC, expressed some pretty negative sentiments about moving to a safe harbor type position at this time. For what it's worth, I agree with that position. I think the space is too nascent, and I think setting up a particular rule set, as attractive in theory as it might be, is not only nearly impossible to implement, but really wouldn't address what we need, which is continued innovation. What I would personally like to see, and Director Hinman did, suggest it was coming, was no action relief that we can start to extrapolate from. So case by case relief, but at least the legal community could start to build some directions. But right now we have nothing.
Yeah, I actually would count that as a form of safe harbor. So sorry, I wasn't clear. I know, like, people think of, oh, it's, Rule 506 under Reg D, that's a safe harbor. But I think, just having some boxes, that someone can look at on the front end, right, and say, I will fit into the, if I fit into this as closely as possible, I will be okay, right? That's at least a starting point. Now, maybe it's too constrained initially if you only have one no action letter, it's too fact specific, but people can build from there.
Exactly.
You have so much enforcement before there's really any guidance, constructive guidance about how to do it the right way, is just an extremely dangerous situation, because it's gonna push people into civil disobedience, I think.
I mean, I think for what it's worth, it's important to note that the reports that have been floating around about plain English language coming from the SEC, I think we're a little bit kind of muddled coming out, but it seems from public remarks by Bill Hinman and Valerie Stepanek at the SEC that the SEC is focused on this, and it's in the pipeline. Whether you should hold your breath until it comes out is probably a different story. But there were some indications that maybe this comes towards the end of the year, and that would hopefully ameliorate some of these issues for participants.
So we're probably going to be wrapping up relatively soon. I think one last thing I'd like everybody maybe to contribute to is, if you're in the developer community, if you're in the just general blockchain community, you're reading this, you're aware of the position, not just on EtherDelta, but where this is going. what are you supposed to do now? Where do you go, with this if you're a potential token issuer, if you're an operator of, some type of quasi decentralized exchange, kind of where are you supposed to go with all this?
I can take maybe a first stab at that. I think a lot of people are looking at this order, and the first take from it is the SEC is coming out against decentralized exchanges, right? But I think if you look at the facts of the case, maybe the proposition that it stands for is that nominally decentralized exchanges aren't really not decentralized, right? Like this guy had control.
Or at least this one is not.
At least this one, yeah. This guy had control of the smart contract. He had a profit motive and was making money off of it. So to me, it kind of dovetails into part of the concerns that the New York AG's office raised about the way that some of these the way that some exchange customers were being misled about the operations and the frameworks of the systems they were interacting with. So I guess maybe that's one slightly contrarian takeaway that I can highlight.
Okay. So what are folks supposed to do right now besides drinking?
What are folks supposed to do? So, I think you need to tread. If you're an exchange, if you're an exchange, don't either be like Coinbase, and just only accept the very, very few that clearly are not securities, or you can get a high level of confidence are not securities, and they must spend so much money on lawyers trying to figure this out. Not as an upstart exchange certainly couldn't apply the same resources. I don't think you can be a new exchange in the U.S. and list anything other than what Coinbase lists, and be able to sleep at night. Other kinds of blockchain startups, it really depends on the specific type, you know what I mean? So I guess I'll just keep it to exchanges for now. I think starting an exchange in the US, unless you just want to copy paste what Coinbase's listings, is, going to be extremely difficult.
Greg?
Yeah, so I agree with what Gabe just said. I think this order emphasizes the position that if you're bringing buyers and sellers together, and part of that process involves your operation of a smart contract, or an individual or entity's ability to profit off of that function, that it's likely that you're going to need to register as a broker-dealer and become an ATS.
Right. I guess the other thing someone could theoretically say, right, is I would never say this, but start one completely anonymously, right? Be like Satoshi. You better have like the best OPSEC in the world, right? Or you're not going to be sleeping, right? Even hackers, even like the best hackers in the world, end up getting caught, right? So I don't think that's going to be a particularly appealing route to anyone, unless you're like a Julian Assange, right? And you're this crazy idealist, and then really is your idealism best applied to DEXs, where people are like flipping things for profit? My guess is not. There are a lot of other cool kinds of decentralized exchanges, decentralized apps that, probably serve more noble purposes that those types of people would want to focus on.
Yeah, no, I'd agree. Although I think it will be interesting to see if someone, comes out with something that is a Satoshi style DEX and what that means. But I do think it's important to really emphasize the critical role that liquidity plays if we're going to have, decentralized applications and a decentralized economy. They simply will not function unless there's a smooth and liquid way for these to be traded. Now, that should be compliant. There should be protections. There should be guardrails that prevent, some of the most manipulative and bad behavior, in my own personal view. But we can't simply say that doesn't work, or there's not a roadmap. And in the same way that allowances have been made for startup fundraising, including through loosening up Regulation D and the revisions to Regulation A, known as Reg A+, maybe we need to do some of that stuff on the exchange side as well, or have another look at that. But I think that's going to be, really a critical step.
Yeah, and Lewis, I would just add, Director Hinman gave that speech in June and talked about, some of the factors that the SEC would examine, particularly with respect to platforms that were either decentralized or intended to become decentralized in terms of conducting the securities law analysis, and provided a potential pathway to non-security status with respect to Ether and with respect to other tokens in decentralized platforms that would enable sort of the exchange of a token without the application of the securities laws. And so I think that as time goes on and as people get more familiar with those factors, and as we get a little bit more clarity around the regulatory position, that we'll see a clearer pathway emerge for those types of platforms. And I think it's critical because we've got developers here who are creating, really awesome stuff, and that's something that we want to encourage.
Absolutely. The other thing on that front is I think we've had and are very fortunate to continue to have a great relationship with the staff of the SEC, and just anyone who's listening, I think the single best thing you can probably do is that engagement with the staff of the SEC. They're ready. They want to engage, and I think the most important thing is if you think you're just going to kind of go out there on your own or publish something on Medium and just say, here's what we're doing, my advice is go talk to the staff, engage with them. They've created a lot of pathways, and see what you can figure out and do that in a constructive way. And it gave you
and since we promised to talk about William Shatner versus pre-mine apologist, I would say you might want to look up William Shatner as well. It turns out he knows if he had a whole this guy pre-mine apologist is basically one of the biggest anti-Ethereum guys out there that you can find on crypto Twitter. And the amazing thing was that out of the blue, William Shatner comes in and just starts quoting all the different ERC standards and how they get approved, and putting him in his place. So I know this is a bit of a non sequitur, but when I saw that, I was like, oh, there's no way that's really William Shatner's account. It's actually William Shatner's account, guys. I mean, maybe he has someone writing for him. I don't know, but he's apparently like a big crypto enthusiast.
That is amazing. Well, look, if you've hung in with us so far, thank you. Most importantly, we'll wrap up where we began. We welcome your feedback. We're here to engage with the community. This is something all of us have dedicated our careers to, and we want to hear what works for you, what doesn't. If there are ways we can help you get there, let us know and give us feedback, because we're gonna, whether you like it or not, we're gonna keep coming with these live casts because we're stubborn as hell. So thank you all. Thanks to my amazing colleagues, and yeah, let's go get them next time.
Have a good weekend.
Bye.